Lordship has passed 2 orders giving a stay of that. And this is pointed out to the High Court. The High Court notes it which had in turn allowed the same regulation 7.3 to operate. The case on the merits is that UGC.
Not I appear for UGC.
1 minute, sir. Allow me to finish, Mr. Verma.
No, allow me to say something.
Allow me to finish, please. I'm sorry. Now, 7.3.
Not I appear for UGC. It's an order of 21st of May. It's an interim order.
Your Lordship
listed along with the transfer petition.
Court order which said you please apply the UGC regulation.
We are issuing notice. Issue notice.
The order should be the same as 365.
We got issue notice on
just see 365
for interim order.
Just see 365 for a minute. Just not.
We'll also issue notice on that.
Yes. Coming on 16th July or would come, there is no date given for the interim in the High Court. So I want to press the interim stay there. Allow me to press it on 16th.
That should make it very clear.
Wait, he will not take it up. He will not take it up.
There is no impediment for the High Court to take up the stay application finally.
Issue a notice also on the interim application. The respondent shall file its response on the application.
Yes.
Orders.
We will.
Whichever the date, 4 weeks.
Now there is
No, it's on 14th. No, the transfer is coming up on 14th.
On the interim after 8 weeks, which expires on 16th July.
No,
Please make it clear that we will press. This is only interlocutory order.
Then you withdraw transfer petition.
For the interim to be vacated, it should not come in the way.
No, they cannot file transfer petition and argue before the High Court.
This will not prevent the High Court from
taking it. That's all your matter. Otherwise,
then let them withdraw transfer petition.
Nothing for us to stay in the High Court.
No. I am asking your Lordship to say that this notice by your Lordships and tagging here will not prevent the High Court from taking up the matter which is coming on 16th.
Then let them withdraw transfer petition, my lord, in that case.
Why should we clarify that?
Because once a Lordship
Yes.
notice here, he will not take it up. But he will not take a parallel.
And they will take these minutes and will say that now this is the observation you follow.
Yes, my lord.
The issue notice goes along with that. And what is the date for? There is no date in
the High Court matter.
No, not High Court. Here, my lord, it's
The High
14th.
Court
for
matter.
us.
Here I am told that it's coming on 14th.
But we will not able to press there. We will not able to press
Computer
there.
date is 14th.
Argument that just because we issue notice, the High Court will not
Yes.
hear the
Yes,
argument.
yes,
It
yes.
depend upon the choice of the High Court.
Yes, my lord.
Yes.
That will make it very clear.
You go and hear the matter.
No. You say just that it will not preclude if I this pendency here should not preclude all this.
That will make it very clear.
Has to be some kind of
It's improper.
exactly.
Only
Not in that case, let them withdraw transfer petition if they can't have both the remedies.
In post we are issuing notice even on the
Yes.
interim.
Yes, not both. Only one submission. Now your lordship has made it very clear, Lord, on 16th, Lord, there is no impediment to proceed with this case by the.
We will say that
Lord, that
transfer
why, Lord,
petition is
in
pending.
presence of all the councils, Lord, when I go and say that, they will say I am upset.
Don't ask.
If I go and ask, Lord, say, get along with the case. But that is why, Lord, this happened, Lord, because the transfer petition we mentioned and we made it very clear. Lord, we will have a difficulty, Lord.
Will not preclude or
That won't be correct.
The universities are there without a vice chancellor for 3 years.
We are not saying anything.
That's correct. But we will say transfer is pending.
Lord, may I say this, Lord? Shall I, Lord, ask the High Court to proceed, Lord? Subject
You
to your
cannot
lordship,
ask
Lord,
any court.
Lord,
You can only
transferred, Lord,
request.
I'm not, Lord, I'm going to tell the High Court, this is transferred, so please take up the matter. Lord, my
then we
learned
will
friends will say that, Lord, no, you should not take up the matter. That is why, Lord, I'm before your
we
lordship.
will say this very
Lord,
petition.
when a transfer petition was
Entirely unjustified.
mentioned it, Lord,
Entirely unjustified.
You will be able to handle that what?
yes,
To
Lord.
hear or not to hear.
great.
Thank you.
Yes, we will inform the High Court that transfer is pending.
Unfortunately, is in the registrar, I believe, on 14th August. This batch of Supreme Court matters for the registrar on 14th August. This is what the order says.
Okay, what we will do is we'll give you liberty to mention the chief.
Okay, go on.
Liberty is granted to the councils to mention for advancing the hearing of these batch of petitions.
That's for petition.
Great. The reference also, right? No?
No, that is
There is a reference.
It's a different question.
Like the irony is Justice Padiwala's judgment has a paragraph saying this very bill which is here has been held by the Honorable Governor to be intra vires. He's got a paragraph
Yes.
actually noting
And
that.
that's been pointed
That is
out.
factually incorrect, my lord. The court has not gone into.
Clear that these are, it doesn't overlap with the other judgment, but.
No, my lord. There is no.
Nothing to do with that one.
Yes.
There is no adjudication on this, my lord. There is no adjudication on this.
Some small submissions, Lord.
Yes.
Some observations have been given as if Lord we have abstracted. We have not abstracted. We only placed Lord that.
It's very
That's
preliminary, Mr. Wilson. We are just issuing notice.
No, against the council, while it is saying against him, my lord, some observation has been made.
To that extent, Lord, not should thank you.
And my lord, next week we'll deal with that, my lord. Next
Millets
week.
will come with all our answers.
Why did you say?
Passing final orders will
Yes,
consider.
Lord, but they have said that I am abstracting all that.
While passing final orders, we will consider that.
Yes, yes, yes.
Yes, grateful.
Grateful to you, Lord. After all, my lord, I am passing on what the High Court, Supreme Court says. Immediately they say, my lord, I am abstracting it. But the Chief Justice said in the open court, my lord, go kneel for respect.
I too was there. I was in chief case. We better list. Say less.
Item 41.
May kindly see page 14. Para 29 of the High Court's order. It's a reversal. And see what's happening, Manoj. I tell you, Lordships, I wouldn't have troubled the Lordships, but now this order is being taken as if title has passed on to them and they have started to harvest the sugarcane that I have actually, I have cultivated. Please kindly see para 29 for a minute. And now it looks like the title has been given to them. And they have now stepped into precisely what is happening. That's why I had in the first place
Restored the trial court's position.
Manoj, it has, but then trial court also ignoring what has happened. Please see para 29, Manoj, for a minute.
They're all interim.
Manoj, interim, but Manoj, they have taken it to be final. That is the problem. Lordship may kindly see these photographs.
Doing the main case.
Lordship may kindly see the photograph. Just kindly see these photographs.
Not going to see.
No, Lordship may kindly see this.
Nothing.
Would your Lordship kindly see, Lord? Just 2 paragraphs I show and then I finish.
2021 suit.
And I have been enjoying an interim order.
For 4 years, you were contesting only an interim order.
Since 2013, I am in possession. And they have clearly violated the order and now they are stepping into it. Otherwise, I wouldn't have troubled your Lordships.
We are not.
Would my Lords kindly see the amount of paper that I have produced?
Proceed with the suit. Some amount.
Well, would your Lordship then kindly give me a time frame? Otherwise, what is happening is that by the time...
We are not inclined to interfere with the order passed by the High Court, which is an interim in nature. We request the trial court to take up and dispose of the suit expeditiously.
Okay.
Request
Item 42.
Yes, madam. And for the appellant, short point of law arises in this matter. Does the NCLT have the power to direct eviction of a licensee despite section 41?
a clause in your license which we could not
Yes, madam.
find.
I'm aware.
Because the clause says that the rents need not have been paid because of the license and other things that you were supposed to.
That was not a subsequent agreement between me and the government. Yes, your Lordships will see that letter.
Both ways.
801. 801. And my lords, please see, this is my letter. They accept the letter. The relevant paragraphs are page 101. Page 102, my lords, the second and third paragraphs, if I may. So the building was not complete. I had to pay money, my lord, to in that sense, to get the occupation certificate for the building. I paid 1 crore of rupees. Page 102, Samiri. Accordingly, we met you in October 20.
Of the above agreement, we were given the premises from leave and license for 5 years. The fit-out period as per the agreement is 60 days, 30 days. As you are aware, after signing the agreement with you and during the fit-out period, several objections. Where does that say that obligation on you to take the license and other things, and in the meanwhile you did not pay rents?
Lord, would your lordship see the second last paragraph at page 102?
102.
You had then mentioned that since there was a defect in the premises,
Read. You had then
mentioned that since there was a defect in the premises as OC, that is occupation certificate, was not there, we would bear the cost for the same, and the same would be adjusted from the license fees, which would be payable from the date of the occupation certificate and excise license.
That doesn't mean a waiver from right.
Correct. Yes, you know.
We agree with you. We have also taken the view that NCLAT can't override existing leases and all that.
Lordship,
They can't become super constitutional authorities.
my lord.
But that doesn't mean that lease and license agreements, the parties need not abide by them, and then the RP can't even ask for rents.
I'm not at all saying that I'm entitled to a full waiver.
Don't pay rents. What is in
But
that?
I have paid in accordance with the interim orders, Lord, I'm up to date. Lord, may I only say this? My only request is, Lord, I paid 1 crore of rupees to get the building completion certificate. It's because of me that the building can be occupied by me, not anybody. That amount should be adjusted against the license fee. I'm only asking, therefore, for 1 crore to be deducted from the total dues payable to the licensor. I'm, of course, not willing to pay the entire license fee. That's not the case at all. If your lordships will see page 103, the director writes back to me. At 103, my lord, the director accepts this. My lord, this is a contract between the parties.
This existed prior to the initiation of CIR.
Yes, this existed prior.
Or not. It shouldn't.
But in the meantime, would your lordships not grant a stay because I've been in possession? I've not yet vacated, Lord. I've been, in that sense, Lord, I've been in premise. I'm not like.
Item 43, your lordship. I'm being led by Mr. Amit Sibal in the matter. He is not present today. He is out of the country.
It's a fresh matter.
Any date after.
It's a fresh matter, minutes, because we've been identical orders.
That's all.
Yes, minutes.
Simple.
Your lordship, there.
My lordship can issue notice, let them answer by then.
Your lordship,
It's a simple premise of delay.
Here also.
There's interim relief.
55 days, minutes. 55 days.
Yeah, delay.
Indeed.
Your lordship, plus.
No, minutes. Before the
No delay.
no delay, minutes. Here, no delay. Before the honorable.
Here before the Supreme Court, 55 days in filing and 226 in refiling.
That's it, before Delhi.
That's right.
That's it.
That is
Not
before the High Court. It's also to be counted.
We will do one thing. This next week. No, week thereafter. This is the first week, 14th, Friday, 18th July.
18th July. Minutes. So,
Item 44.
please, madam. Madam, I'm asking only 7 days from today, madam. Madam, any of the rent is not dues. All rent was paid. You kindly see the.
Where is the proof you paid?
Madam, kindly see the page number, the SLB, page number 36. Madam, page number 36, SLB. SLB, page number 36.
And I'm doing 101%.
Page number 36, I give you a chart. And the proof is correct. And the proof is
You
another page.
paid up to 6/11/24.
But,
Where is the
No.
current payment?
Madam, after that, January also I paid.
We will impose heavy cost on you.
Madam, kindly see the chart first line, madam. 6 month advance is there, madam. The chart in the
First pay and get back your advance. Clear there. And vacate.
You don't vacate, you will just.
Madam, I'm
That you issue contempt if you don't vacate within time.
madam,
Only
only
misuse the liberty that is given to you.
only 7 days, madam.
You
I'm
just
just
dismiss. You don't misuse your liberty granted to you like this.
Item 45.
Thing, Milord, I am appearing for the petitioner in item 45.
Yes.
Lord, may kindly see para 34 of page 15 of the impugned order, the finding in my favor that I have a plausible, reasonable defense raising triable issues. But in lieu of and still the court says you deposit the entire claimed amount in the court. Lord B.L. Kashyap, this honorable court clearly says that if I have a reasonable, plausible defense, I'm entitled to leave without any condition. So, Milord, it is clearly in the teeth of the provision as well as the judge.
I don't.
And Milord, I am a scheduled bank.
Doesn't matter. They gave you the freedom to contest the case. If
Lord, that I'm entitled to, my lord, in view of the finding. Lord, may kindly see the finding in para 34. I have a, my lord, in fact, it's a 2017 invoice presented against the LC after 2 years in 2019.
Drag on the LC like unendingly and
And Lord, may kindly consider 2020 is the suit. Lord, 2020 is the suit. In 2025, they grant me leave. And of course, my Lord, may kindly permit me to cite.
You're not inclined, you want a breather, you come after vacation. You see, you're not inclined to.
My Lord, allow me, my Lord, I'm grateful for the observation. Allow me to cite one paragraph of BL Kashyap judgment. My Lord would feel satisfied.
You don't want to discuss in a vacation board if you want.
Lord, may kindly see just one paragraph of this judgment.
Let's this.
Clearly saying, my Lord.
Correct, no? 2019 also. Tell us what you want to show.
Lord, may kindly permit me to read para 33(2) of this judgment for my Lord, just 5 lines, my Lord.
Yeah, sure. The same condition should not be imposed. That's all. I know that.
Yeah, my Lord, it says that I have a plausible defense, no condition. My Lord, para 33.2.
No, bar.
The page would be 310.
We got it. Read it.
Thus, it could be seen that in the case of a substantial defense, the defendant is entitled to unconditional leave. And even in case of a triable issue on a fair and reasonable defense, the defendant is ordinarily entitled to unconditional leave to defend. Lord, may kindly see para 34 of the impugned judgment. The court says that there is a serious issue of interpretation of LC, and hence it is raising a substantial question as a triable issue, and absolutely no special circumstance noticed or even in fact is there in the case to direct me to such a unreasonable, harsh condition that entire 20 crore.
Observations are there, but then the whole purpose of granting a standby letters of credit will completely be lost.
Yeah, I quite follow that. But here, there is a specific condition.
Don't pay. What happens? I don't know. High Court was rather liberal in making that.
What I humbly submit is, the timeline in the LC is he will make a claim within 60 days. He makes it after 2 years.
The total LC?
The total LC, in fact, in the impugned order recorded is 11 crore. The direction to deposit me is 20 crore. Well, may kindly see the LC reproduced in the impugned judgment.
They got noticed.
I'm so grateful, Milord.
If you thusly let them come immediately, we'll see.
Milord, there is a direction.
Now, we'll just pass, we'll hear them and then pass orders for first week.
Lord, may consider on reopening because I am directed to deposit.
We are giving it to you on the.
Grateful, Lord. Much obliged.
Giving it to you on the first week.
So grateful. So grateful.
Yes.
Lord, just have a look at the clause not at 155, the line of credit.
It rejected.
Line of credit is not.
LOIs is already given Mr. Vikas Singh to the other side.
No, not even.
What?
There was a status quo order. We approached the High Court within 4 days.
Because of the importance. Yes.
And the High Court not granted me a status, and this order is only passed on 1st of July, which is day before yesterday. So we've approached within not 2 days. Just have a look at the clause not at 155.
It's not to the High Court. High Court is.
High Court has given something additional which is not even their case.
Status quo was granted. It says yes, violated trans 2.4.
Not straight. Every bid is stayed like this in
No, I'm not.
All related matters.
If my bid is rejected like this, Lord, just see Lord the clause.
But there is a reason. Class 2.2 of the tender conditions violated.
That is not even their case, Lord. That is not their case. That is not the ground for rejection. The ground for rejection is 3(1)(d) only. Just see 155, Lord. I have a line of credit. just 155 Lord. I am non-suited only on this ground. Clause D.
There are
PDF may be
not
180.
just that, there are multiple reasons.
So there is no other reason. Don't
The
just
High
only
Court
that.
has recorded.
So High Court has gone into something which was not even the range. Lord Mohinder Singh will clearly violated.
In a tender matter,
I'll explain that
the
also.
public, larger public.
I'll explain that also.
interest involved.
I'll explain that also. Lord, I'll satisfy your
155.
155. Lord, PDF will be 185.
Yes, tell us.
Just see working capital, Lord, clause D.
Ah.
Evidence of possessing adequate working capital, at least 20% of the annualized value or estimated value, whichever is less of this work. So 20% is not 256 crore, inclusive of access to lines of credit and availability of other financial resources. So what all blood working capital, lines of credit and other financial resources. I should combine this and have 128 crore. Combine these two, three. Working capital, access to credit and financial resources.
Yes.
The bidder should possess the working capital within 3 months prior to the initial scheduled date of opening. So that is not against me. I am within 3 months. In case a JV consortium, the lead member shall have to possess at least 50%. I possess not 90%. 50% share another member
All
shall
that
have
is explained in that.
Pardon?
All that is explained in.
No, I'll explain. What is the High Court? I'll tell you. High Court says that in the working capital, your contribution of working capital is 1.5 crore, 1.5%, and rest is your lines of credit. But where is that requirement? It's not that it should not be. Just see this. This is the only ground. Just see page 26 in the impugned order, not why the High Court rejects it. This is the only ground. Page 26. Sorry, page 20, para 26. Page 38. Page 38.
Yeah, yes.
The factual aspects of the case have already been discussed at length by us, and what we could congregate is that clause 3.1.d and 2 and 2 have not been rigorously adhered. Now, 2.2 is not the ground for rejection. I'll just show that. Rejection is only 3.1d. Though the reasons for disqualification have been restricted to the eligibility criteria as clause 3.1d, the working capital certificate submitted by the chartered accountant in tabular form as per the bidding document is the bone of contention. Learned senior counsel for the petitioner has confronted such reasons by accentuating the absence of any proportion of working capital and line of credit and availability of other financial resources in the terms and conditions of the tender. But at the same time, what appears to be glaring is the almost negligible amount of working capital put forward by the joint venture. The working capital certificate of the chartered accountant also is an ambiguous document, as though it mentions about the line of credit and availability of other financial resources as on 30/11/24. But the memorandum of understanding, as we have pointed out, are all executed post 30/11/24. The other factors which we have noted are acceptance to the submission of the learned counsel for the
We are not inclined.
Lord, I'll tell you, Lordship, in my MOU, I'll give them 9% for the line of credit. I also in my MOU with them say I'll give you 3% of the profit. That doesn't make them a member of the joint venture, Lord, which is not even the ground for rejection. The High Court takes that as a ground for rejection. The order of the tender condition, Lord, doesn't specify the percentage of working capital. That working capital and line of credit should be in some particular percentage.
Even with respect to
I am meeting all the other eligibility criteria. I am not meeting all the other, only this working capital, which is not includes lines of line of credit. Line of credit, I will not have 150 crore. I have 150 crore of just see not the 3 certificate which I have not line of credit at 305 crore. These are the 3 people who have given me lot access to line of credit.
Okay.
305 lot at 380 PDF 335.
I don't see any perversity in the order. 320?
305. 305, this will be annexure P7, part of P7.
Yes, yes.
Barbik project has got a surplus of 103 crore. It has promised to give me 75 crore. Then Lord, the next.
Very clearly considered.
No, not all the Lord, the only reason. Lord, please appreciate, Lord. I would have not completely bowed down to what your lordships are saying. If the tender had said that there has to be a proportion of working capital vis-a-vis the line of credit, the tender doesn't say so. So you can't not include a term in the tender which is not there in the original tender. Lord, why am not I'm saying this? Not because recently there was a case. Not these tender documents are formulated not with a consultant. And consultant will not makes a document in such a manner that there is no subjectivity with the tendering authority. If you give subjectivity,
going back,
this is what has been done.
Not documents formulated, all that. It's all
No, this document is this 155 lot is the line of credit which is not included as part of working capital. In 155, if they wanted to specify that this working capital, your own should be 50% of your total not working capital, then not I could have understood them should. But if the clause doesn't say any percentage not of working capital by me, and if my line of credit is something like not a banker may give me money for the purposes of investing in a project. I have 3 people investing in the project where not they are. I have to give them interest for whatever money.
It's not so much of an issue for us to interfere in a tender matter of this. There are glaring cases, but this is
not. I have 500 crore less. Not it's a handling contract for 9-8 years. Less. Public money will not ultimately will be going, and you are rejecting somebody on some frivolous, completely contrary to the not specification given in the tender. Not then could I not pray to your lordship about giving that, but on the other side, could your lordship that place it before the regular bench?
Sorry?
Your lordship for giving that liberty to the other side. Could your lordship place it in the regular bench, regular court?
They've heard you.
But
heard you
with great respect, Lord, I think
where there is a marginal error, we can do it.
No, it's not a question of marginal error. Lord, please see the laws which I just have a look at.
That's not right.
I have not. Let me.
That's
just,
not right, you say.
Yes, then I.
Your experience, you should be the same.
So just see the clause once again, Lord, at 155. I'll stop that.
Yeah, sure. You argue 150?
155. Evidence of which will be brought PDF 155.
155.
Evidence of possessing adequate working capital, at least 20% of the analyzed value of estimated, whichever is less. This I will be covering, inclusive of access to lines of credit and availability of other financial resources to meet the requirement. So I am meeting the total of 20%. That's not a problem.
The argument that was raised and argued by you in the High Court.
No, I'm trying to say something. What has gone against me? The High Court non-suits me on the ground that my own working capital is 1.5% of the total working capital that I have arranged from somebody else. That is not requirement in the tender. If the tender had said that my own working capital had to be in a particular proportion, then High Court saying that I'm not, or the CCL saying that I'm not eligible, would have been justified. But if this tender doesn't say so, just visualize a situation, where I had line of credit from a bank. A bank gives me a 200 crore credit facility. That 200 crore credit facility, because I have only 1.5 crore of my own, so this you will be non-suited is what the impute order is saying, or what the CCL is saying.
Okay.
I have a line of credit which is far more than what is required.
We leave it at that. Thank you. I think this
Everyone's. But it's High Court in a criminal review.
Non-exclusive 319.
319. Trial is over. Today there is no trial reserved for judgment. At the time passing the order, one visiting
will issue notice.
First, kindly stay because he's only an investor and he's outside India.
Stay.
I'm grateful.
Item 48.
Well, in this bit of check amount was at 20 lakh. Already I had paid a compensation
138. All through you lost.
So I already paid the entire amount.
No scope. No scope whatsoever.
I already paid the entire amount, the check amount of 20 lakh. So the imprisonment is 1 year. I wonder.
Difficult. And 913 days delay, sir. What are you doing? Dismissed. 50?
49.
49.
Questions? I was convicted for 5 years and thereafter I filed a revision petition. Revision was dismissed ex parte motions. Your lordships have consistently held that either amicus curiae may be appointed or the assistance of the legal aid may be taken.
That
Thereafter,
you're
on
making
wrong
an
advice.
excuse, isn't it? This was not heard in appellate court.
That is what his submission is.
Thereafter, or wrong advice.
Actually, an ex parte. They considered it.
Yes, Lordship, may I-
And
may I-
you filed an
Lordship,
application.
Yes,
Normally, such an application is not maintainable.
Yes,
But High
that
Court
was
was
wrong,
kind to
wrong
you.
advice.
But High Court was kind to you.
Lordship, may I
Took up that application and reheard your case.
may I just take one para of this. Para 3.
What is this?
Para 3 on the same law point. It is not an issue that the High Court has proceeded to dismiss the criminal revision of the appellant against his conviction in the absence of his counsel without appointing an amicus curiae or taking the assistance of the legal aid available in the High Court Legal Service Committee. As such, the impugned order cannot be sustained. The same is accordingly set aside and the criminal revision of the High Court be restored to its original number. The revision be decided in accordance.
It's too late for you to say because you already went back to the High Court. High Court heard you in your
Lordship,
application. There is a second impugned order here.
That was not third Lordship. That was not
Second
maintainable.
order.
Yes, Lordship, that was not
You were
maintainable.
saying that even in the later order, you were not here, 5525?
Yes, Lordship. It was a
It
recall
was the
order.
5525.
It was a recall order, Lordship.
Read
Kindly
that. Look at
recall
that.
order.
Look at that order, sir.
Yes. And kindly see page 7, Lordship, of this also. Page 7.
Page 7.
With respect to the prayer sought by the revisionist that after restoring the case, here the present case again on
With
merit.
respect to the prayer sought by the revisionist and after resorting to it, here the present case again on merits.
Yes, Lordship. It is relevant to Parallel section 360, which reads as well.
The
Same as shown.
order was passed on the merits.
Since the judgment is not meant
Give me an opportunity.
to sustain.
We'll issue notice. There is right. Though you have, High Court has twice over revisited the matter, you will have the satisfaction of being heard. Take out NSC, take out notice, issue notice.
We should say one more small solution.
Yeah.
I'm a cancer patient since 2021.
So,
5 years. And
Issue notice.
39 years old, Lordships, may
Yeah,
I
issue
make a
notice.
prayer for interim bail in the meantime, Lordships?
no. Issue notice.
Returnable date.
Even on, yes, yes, after 2 weeks.
I'm grateful. Okay.
Item 50.
15. Now it's coming up on Justice Guge's hearing it on 14th July. It's listed. It's listed. 51.
I have a very serious preliminary objection on 51.
51, Mr. Rohtagi is appearing.
A statement of your lordship.
Which item is yours? I'm sorry, we have jumped. No. Come.
I have a preliminary objection 51 before lordship starts.
I didn't know the small criminal matter would have such formidable opponents on both sides.
Previous hurt.
Can I indicate how it's an abuse of process by the complainant? I have suffered 13 injuries on the one on the head. The police files an FIR at my instance, arrests the complainant. He has an eye injury when he is arrested on 29 December 2023. So in my FIR, the complainant of the present case is
Yours is on December 23.
I'm grateful at 7 a.m.
Then in June 24, they filed this.
Milos, I'm very clear. He files a 156(3) first, which is rejected, saying that the police has given a report trying to, you are falsely pleading that 6:30, that is half an hour before the present incident, you have developed an eye injury. The police arrest this complainant, and actually, Milos, he has an eye injury. So he now palms that eye
Watch
injury.
proceedings.
Yes, Milos, but it's an abuse of process, Milos.
Watch proceedings.
Yes, Milos, but it's,
They has to examine the matter.
Milos, therefore it's an abuse of process by him. 326 is invoked so that I get arrested. Milos, just see, I have suffered 13 injuries.
Whether it's a counter blast, not counter.
It has been found to be a counter blast, Milos. I'll show the order of the learned.
It's found, then why was it dismissed?
Milos, the magistrate gave him an option to file a private complaint. Milos, can I just indicate what happened? 29 December is the incident. He is arrested. The complainant is arrested, taken to jail.
My lord, I appear for the complainant in this matter, my lord. My lord, I may just point out.
What do you want?
My lord, I appear for the complainant in this matter, my lord. Both the FIR of the complainant as well as the FIR lodged by the petitioners relate to the same incident, my lord. It is
We have
just
not
that.
even called upon you. Why are you showing over anxiety? You are still hearing him. Just tell
My
him.
apologies, my lord.
After my FIR is lodged, can I just indicate the facts again?
Just show us from the High Court judgment.
Yes, because High Court says these are factual disputes. I don't want to get into it.
Then what else?
So therefore, please see the magistrate's order.
What do you want? What
Because
are
I
you
want-
expecting as per Bhajanlal's principle?
Because what I'm saying is,
Further.
because this is a complete abuse of process. Because why, because I'm telling the lordships is, I suffered 13 injuries. The police lodges his FIR at my instance, charge sheets him, arrests him on 29 December at 4 o'clock. He has eye injury in his eye when he's arrested. After that, after that, he makes the 156(3) complaint. Now, please see the magistrate's order at page 62. Page 62, Milos.
Tell us the incident that they referred to in their complaint.
Because that incident,
The date of that incident.
same day as my FIR, half an hour prior to my FIR. So they changed that FIR and say, please,
Prior to means that your incident is of
7 a.m.
Date.
29 December. 29 December.
26, 29, 12, 23.
1 month's delay.
Yeah, and then he files 156(3) first. The magistrate dismisses as saying that, this is a complete abuse of process, a counter blast. But unfortunately, the magistrate gives him a liberty to file a private complaint. Taking umbrage under that, they file a private complaint. Now for 326, I am summoned.
What do you say?
My lord, the 1 month delay is
You
attributed.
only talk about the delay part of it.
My lord, there is no delay. The contention was that the incident relates to the same date, my lord. There was error on the part of the counsel making that complaint that instead of mentioning December, 23rd of December, he wrote 23rd of November, my lord. And that was the only reason which resulted in the magistrate first opining that it is a counterblast to the...
The application was filed by you on 8th of January.
Yes, sir.
After the incident, even assuming that the
approach
29th of December is the action, is the event, and then you have invoked 156(3)
Yes, sir.
only on 8th of January.
My lord,
And thereafter again, which was dismissed on 17th December,
Right.
and then you go and file the complaint on 5th of June.
Correct.
This
Absolutely.
aspect of it, this analysis is not much there.
my lord, may kindly see the order.
Anyway, you file your counter, we are issuing notice.
Lordship I may not be arrested because the High Court has directed me to
Pending
surrender.
disposal, the petitioner shall
My
not be
lord, may
arrested.
kindly consider may kindly see the order.
We'll examine it,
Obliged. Item 51.
51, my serious primary objection.
14th July, it's listed.
You know, one more thing.
Milord, I beg to appear, Milord, for the-
No,
Let them start.
Milord, can I make a
argued
submission?
fixed on 14 at their consent, and yesterday it is mentioned.
Milord, can I make my submission, Milord?
29th
I
May
appear
order,
for the petition.
not 30th. It's against the trial court order avoiding my caveat. We kept it.
Wait.
Milord,
Petitioner, so,
Milord, can I make my submission, please?
yes.
Milord, I appear for the petition.
I think you should be permitted to make all the submissions before the High Court.
Yeah, so I only want to say one thing. Milord, for the last 3 weeks, we haven't got a hearing in the High Court. 3
That we
benches
saw.
have recused. Now the problem is, Milord, I am the MD of HDFC Bank. I have nothing to do, Milord, with interest disputes of Leelavati trustees. Now I am being roped in. Milord, the bank is suffering. Milord, I want interim protection till the matter is heard. This 14th is given, Milord, 1 week ago. And Milord, the date is now 1 week hence. From 12th of June.
So what do you want us to do? Your case is listed on 14th. Now go ahead.
Now, Milord, I don't even know whether 14th it will be heard or not. Because
When
one
you
judge
come back
said,
after 14th, we'll see. But what is it that we are going to do now?
I want to tell your lordship this.
It is
Milord, the
like
bank
advance
is...
ruling. Assuming High Court
No,
will
I
take it
don't
up.
want an advance ruling. I am saying, Milord, a frivolous, Milord, FIR lodged against, Milord, the MD of the bank because of personal disputes. I am saying no proceeding should be taken
All that you
against
should
me.
argue there, Mr. Rohangi, not here.
But Milord, I don't get a
In view
hearing
of the,
from
we
12th
are
of June.
informed that the case is listed for hearing on the 14th of July. In this view of the
May
matter,
I say one
there's
thing,
no
Milord?
occasion for us to entertain the case, especially
Best, we have been mentioning.
Milord, your lordship will listen.
I have been there in all days, in Bombay High Court.
We
Your lordship
understand.
will listen on
One
Monday.
day,
Sympathize with,
one line,
you're saying something in your favor. We sympathize that the quash proceedings were initiated way back on 2nd of June 2025. We don't really know. 12th of June 25. Since then, bench after bench has recused for whatever reason.
Then what am I to do, Milord?
But we understand that, but it's unfortunate.
Judges said it's
Now
taken up by
now that it is listed for hearing,
there are two difficulties, now, and that is why, they're here. Number one,
Milord, your lordship may list it next week.
recipe stated, my lord, in one of the cases in Nilavati matters, one of the judges on 14th had already recused once. Two, my lord, we tried our level best, even the fresh matters when that was mentioned after so many days.
thank you.
So you advance recusal, so today he will anticipating.
Milord, may I say this?
There is,
We are just, we are not entertaining. Nothing more.
my lord will do, we will, in that case, my lord, we will withdraw two, my lord.
Sorry?
My lord, can I, only one request, my lord. In that case, if my lord.
Mr. Singh, 1 minute. Milord, can your lordship list it next week?
There's some problem, Mr. Rohit, we can't hear you. Unmute.
Can your lordship put it, Milord, on Monday or Tuesday?
It's coming on 14.
Why? It will be improper. The case is listed on 12th. You come back. Come back. It's listed for the 14th.
Abad Konda and Mr. Desai argued.
What's your apprehension, Mr. Rohit? 1 minute. We can't hear you. There's something wrong with your microphone.
Can your lordship hear me, Milord?
Now we can hear you. Tell us.
Milord, my apprehension is this, that, Milord, the bank has been roped in a private dispute of trustees. Milord, my reputation is suffering every day. The idea is to summon the MD to the police station, Milord, and create havoc for the bank. I don't get a hearing. I am therefore saying, Milord, that no proceedings should be taken against the MD. They can go on with their disputes.
Okay, two things. First is you have addressed on the merits of the matter. We will not apply our mind. Second is the case is listed on the 14th. There is no dispute about that fact.
May I
only say 14th. If they are not, you are not. Then you come back to us. Same order, same order.
Right.
Thank you.
David, clarify that it is not, we have not heard on, it was not argued on merit, sir.
Obviously. Our order is we are not interfering in view of the fact that the case is listed on the 14th.
Milord, could your lordship observe that it will be heard on the 14th? I don't even know whether it will be heard on the 14th.
We hope and trust that the High Court will take it up and dispose it off. High Court will take up the matter on the 14th. Our observation is more than enough.
Fair enough, Milord.
We have noted, SLK, we have noted that the what's item 5?
51.
We have noted that the case was initially listed for hearing on, it was listed for hearing on 12/6/2025, 18/6/25.
First on 18, first on 18.
12/6/25.
is the filing date.
18/6/25, 18/6/25, 26/25, and also on 25/6/2025, also 26/6/25. We hope and trust that the matter will be taken up on the designated date, that is on 14th of July 2025.
Those are
With these observations, especially petition. Doesn't matter, Mr. Just indicated, that's all. Make sure that the matter is taken up. That's all.
May it please, Your Lordships, I beg to appeal for the petitioner. Because the short point in this.
Because there's an issue. All issues will be left open.
Excellent. We have not even entertained. Not even entertained. Our first paragraph says we are not inclined to entertain.
May it please, Your Lordships, because I beg to appeal for the petitioner. Because I beg to appeal for the petitioner. Because the issue here is because from the stage of summons.
Yes.
Because I'm so sorry. Because from the stage of summons till the stage of issuance of show cause notice, there is an elaborate procedure for personal hearing. That personal hearing has been given a total go by. Now, the personal hearing is under a statute, Rule 1. Notice has to be appended on the website. Once it is put on the website, I get a notification. I'm so sorry. I'm so sorry.
Avail
I'm so
your
sorry.
alternative remedy. Thank you.
No, this is not an alternate remedy. This is an error in the impugned order.
107.
The impugned order, no, impugned order says the alternate remedy, it's an appeal against the issuance of show cause. Because that is always there with me. But it is like saying ousted from trial, but you have the chance to go for an appeal, so you go for an appeal. But because the trial was not conducted in my case, that is the main grievance I have.
We'll leave it at that. Next. What happened?
We are thankful to our lordships.
You could settle it.
Because there is no settlement. I'll make that clear.
Final settlement letter. This is the proposal and we have paid it.
By 3rd of July, that is yesterday.
We are asking whether there is a settlement or not.
There is none. There is none. There is none. In fact, they gave us a wrong UTR number saying they have transmitted some funds to that UTR number. And therefore, my lord, so far as we are concerned, there is no
Lordship, may
settlement.
kindly see that.
He is not
There
agreeing.
is no settlement.
Just Lordship, may kindly see their offer letter first. We don't want.
We are not getting.
Whether he is agreeing that there is an offer letter by him.
Makes no difference.
Right, that's what I'm.
Baron, answer our question.
Yes, my lord, so deposited.
Our simple question is there a settlement or not?
Yes, my lord. That's
No.
what I'm just Lordship.
Shows that
this is the
settlement.
letter.
Shows that.
This is a letter from them. This is 2nd July. 2nd July is your Lordship. Hear the matter. When we said that we are before them and we are negotiating, this is the negotiation finally culminated into the
It
offer.
is their letter, is it?
Yes, my lord. Yes, my lord. It is 4.5 crores.
Discuss one. So
Please,
the amount of received 1 minute after receiving your access has agreed on an exceptional basis and without setting it there to settle a 45
Crores.
crores,
4.5 crores.
4.5 crores
On my lord.
upon receipt and successful clearance.
Next column is.
Above mentioned, please note that as per the original terms and conditions below, this offer is strictly confidential. So, till what time? Comply with the terms and conditions.
Second table is 3rd July is the offer for us. We have to pay. Lordship, kindly, what are the conditions?
Where is the, by what?
This is the first transfer, online transfer, my lord.
Which is, wait a minute, where is honor 45 crores or to be deposited?
4.5 crores.
4.5 honor before 3rd July.
3rd July, my lord. Now, Lordship, kindly come to the next.
Have you deposited?
Yes, my lord.
No, my
Online transfer. First thing is at the 3 and 3.
2 crores, 1
15
minute, 2
hours.
crores of 3rd July.
15 hours, my lord.
1 minute, 1 minute, 1 minute. Second one is what, 2 lakhs, 10,000? How much is this?
Axilo fine service, my lord. That is advance.
It is.
Then next, my lord, 2.10.
So all put together, how much?
And my lord, 4.5 crore on
What?
card.
Satyendra, please have a look at it. Your letter and this amount, everything is done.
My lord, then the conditions kindly.
Have you given copy to him?
Yes, my lord. To the advocate and record, we have given them copy. That may kindly see now below the table. What are the things which they have agreed if I pay?
There.
First page itself, below the chart, my lord, upon receipt of successful clearance of above mentioned settlement, we will issue a final statement reflecting zero outstanding due in the educational institution loan account subsidiary.
Have they issued?
Subsequently, the loan, they are not issued that. The loan account shall be considered closed. All legal proceedings initiated by either party shall be collateral mortgage property shall be released. Again, no new certificate shall be issued. This is what they have to do now. Yes.
Now, Satyendra, tell us.
Because I don't have a copy of the letter my friend
They
is
have served
referring.
yesterday itself to your.
Okay. All right, have a look at it in the meanwhile, issue notice and stay.
Please.
Because Lordship will just keep it on Monday. I'll take
Yes,
I
yes,
want
keep
to
it on.
really assure your Lordships that we are not taking any steps. Lordship will
Have a
just
look
keep
at
it on
it
Monday.
because prima facie.
I'll
the
have a
proof
look
is
at
here.
I am not.
I have a look at it. I'm sorry
Friday
that I
next
didn't
week.
have this letter. Lordship will just have it on Monday.
Right.
After 2 weeks.
After 2. Come after 2 weeks, check it after then.
Just in addition.
He's taking notice.
Yes.
Grateful to you.
Well, stay.
Yes.
I'm great. But this is because on that days, 2 minutes of your lordships Intelligence has done this. We are grateful. It's an education institution, 216 students, my lord.
All right.
From 4th class to 12th class, they are pursued. I'm grateful.
Right, right.
Yeah, deeply grateful to you.
Item 54.
Please, my lord. The lordships were pleased to issue notice on 25th of February. The urgency now is, my lord, that in May, my lords, they have now come up with an examination. Lord, this will, my lords, completely vitiate the, my lords, the status as it
Then itself
existing
we have
today.
told you at that time
The
itself.
lordship
that we
served
will
the
not say
state.
that.
Yes, Lord, lordship said that let the state come and, my lords, inform your lordship, the state has been served. Lord, 906 people, Lord, they were selected in the second requisition list. That came to be challenged, your lordships are aware.
You were selected, no?
Yes, my lord. That came to be challenged for the High Court. The High Court struck it down. Now, my lord, matter travelled here.
Candidates filed repetition.
Yes, my lord. And matter travelled here. Lordships were pleased to uphold that second revision requisition list. Now, after having done that, the state, my lord, clandestinely filed an affidavit here, saying that these 906 also should be shunted out, and there is a third, my lord, so-called requisition list. Lords, once your lordships have upheld, where is the question of the state now trying to, my lords, oust us?
What was our order? Show us our order.
Lords, notice, my lord.
30th of July 2019 order.
Yes, my lord. Now kindly see, my lord, that order, judgment we have placed. Lords, kindly see.
So what are our directions in that?
Yes, my lord. Before that, I just want
221, I think.
things, my lord.
221, right?
Yes, my lord. Before that, I just want to point out two things, my lord, if your lordship permit me. My lord said page 240, the act and the rules are noted. Is important because now they say, my lord, the second requisition is against the act and the rules, Reservation Act. Then, my lords, kindly see page 242. This is the, my lords, original requisition list, which is noted. Then, my lords, at page 243, my lord, the court says that the second requisition list was brought in to ensure compliance. Kindly see this from the above tabular column.
This was long back we have seen, but just give us a little
yes,
a preview of that.
Yes, no.
So initially the advertisement was issued, and there was.
I'll give the dates, not just a couple of dates. There's a chart I handed up last time. We are a batch. In fact, it was mentioned on Monday. They should have listed the batch. There's still only one.
All three matters. What's the point? One is mentioned.
No, but that's okay.
Go by
Mr. Kamat's paperwork should be good.
No, you tell us basic facts.
Yes, the basic facts.
Read it long back.
Look, there was an advertisement which was issued on 26 December 2013.
26 December
2013, my lord. And this was for, my lord, 6,628 posts.
6,000 posts. Okay.
Yes, my lord.
What posts are they?
My lord, these are, my lord, subordinate agricultural, my lord, services. Yes.
Okay, take it.
Now, my lords, out of this, my lord, the unreserved was 3616.
Is state here?
President state.
State
In fact, Lakshis, there is something that I need to explain in this matter.
No, we will ask you after they finish.
Yes.
Unreserved? What
Unreserved is 3616.
Yes.
SC 2211. ST 235. And OBC, my lords, 566. The first column of that chart. If lordship sees my chart. Now, my lords, there is a second requisition which comes in. Now, my lord, that changes and brings down. Yes, my lord. Okay. Next, about 10 months later, 20th of August 2014. That is challenge. This, my lord, brings down, if your lordship sees, my lord, from the unreserved 3616, 515, from 2211, etc. My lord. Now, my lords, we are selected based on the second requisition list. This is challenged before the High Court, saying that the rules of the game cannot be changed. My lordships, that judgment of your lordship, the rules of the game cannot be changed after, my lords, the process has begun. The High Court, my lord, strikes it down, the second requisition list. Matter comes up to your lordship's court. There's a second requisition list, which is
so your appointments. You were
yes, my lord. So we should have been given appointment.
We should have been given appointment.
Then what happened?
Now, my lords, when the matter is pending here, they file an affidavit.
Those matters are still pending.
No, my lords, when the matter was then pending, they file an affidavit saying that 906 people should be ousted because it is, my lords, against the act and the rules, the reservation has been exceeded. Your lordships will not get into it. And my lords, I showed page 243 and uphold the
6 of those who are appointed are over and above 50%. That is why they say excessive.
Lord, that was never the subject matter.
That was the argument.
That was the argument, Lord. Your lordships upheld the second requisition list, which I showed at page 243. Having upheld it, my lord, these 906 people, for no fault of theirs, my lord, have now been, my lord, chasing the courts.
What happened after that?
Lord, under one lordship said under 140.
We have allowed that SLP.
Yes, Lord.
After the what is the subsequent?
Lord, lordship said under 142 we can't give you relief because this was never the subject matter, my lord, anywhere. So we file a fresh writ, my lord, before your lordship's court. Lordship said go back to the High Court. We went to the High Court. High Court says now it is covered by Anupal Singh. That's how, my lord, we are again before your lordship.
Since when were you working?
Lords, we have not been given appointment.
After the High Court set aside your appointment.
Yes, my lord.
When you came here, were you taken back?
No, my lords, we were not given appointment.
Let me just clarify. 906 were not given appointment. Yes, they were not given at the start.
Selected but not given.
Despite the fact that we come.
What is the urgency?
Not the urgency now is, my lord.
My lord, which are there, which are now being carried forward, my lords, and we filled up this.
So there are 3, 4, 4, 6 vacancies for which an advertisement
went back to the High Court, virtually asking for implementation of this court's order.
Yes.
Yes, my lord.
Where we have reversed the High Court's judgment and said that you will be entitled to, but then that wasn't given to you.
Also, my lordship said 906, we can't interfere in 142. My lord. That was what my lordship said.
Appointment orders.
As far as appointment orders are concerned.
Without any relief to you.
Yes, all your lordship said is that appointment orders cannot be issued under 142, while upholding the requisition pursuant to which I was appointed.
So then what did you do about that?
But then
That's the repetition.
That's it. That's it. Now, just one
We
small
have to
thing.
hear you. What's
May I just finish this off?
any further?
That advertisement that was issued, we brought it to the notice of this court when your lordship.
So now the new advertisement is for how many posts?
3, 4, 4, 6. Of the 3, 4, 4, 6, 906 would be earmarked for us. Therefore, when this exam is conducted on 13th, it's going to be conducted on 13th. At 906, now there will be a claim laid by the new candidates.
This is not a matter which can be resolved through interim orders.
No.
We asked them.
Lordships, in fact, there are certain facts about this case that are not being placed before this honorable court. Lordships have, in fact, in Anupal Singh, Lordships have dismissed their appeal. And Lordships, the reasonings have been given at page 269. It might take Lordships to page 269, para 75. This will make it very clear what they have been concealing. May I read out with Lordships?
From where do we see that?
Lordships, the petition before, which is before this honorable court, Kaushal Singh, and this is at page 269, para 75. And this is the judgment of this honorable court, which goes by the name of Anupal Singh, which they were just referring to.
269.
The judgment starts, of course, from page 21, but I will take directly Lordships to page 269.
Why should tell us instead of reading?
Yes. Lordships, I'll just read out, pointing out that even presently, this is honorable court's judgment.
Yes.
There are 2779 vacancies, and that 906 vacancies are kept apart. Mr. Mehul Gupta, appearing for 906 candidates, has submitted that 906 candidates can be accommodated in the aforesaid 2779 vacant posts existing as on date. Extension does not merit acceptance. The present vacancies of 4838 and the available vacancies, that is 2779, are the future vacancies which are to be filled up by a fresh advertisement and by participation of all the eligible candidates, including the 906 candidates and other unsuccessful candidates. 2779 vacancies existing as on date, which are the vacancies as on date, that is 2019, cannot be filled up by the candidates who got selected pursuant to the advertisement in 2013-2014. Lordships, thereafter, At page 270, para 76, the Honorable Court then goes on to say that no direction can be issued to the State of UP to issue the appointment orders to the 906 candidates. One minute, I'm still on minutes.
Yes.
Lorships, then at para 76 at page 270, the court clearly tells that no direction can be issued again for appointment of the 906 candidates. And the summary is at page 77. It's one line. Just one line. Para 77, page 271 and 272. One-time age relaxation has been given to them in the upcoming recruitment for the 906. So this is
What did the court do? It's they left it in the lurch.
after that, what has happened?
Yeah.
After that, they filed for a clarification. That was dismissed. They filed a review. That was also dismissed. So this matter has.
They were also permitted to participate.
They were. They can. In fact, the petitioner.
Did anyone of them participate?
Yes, one of them has participated.
One of them
Mr. Kaushaldar, who's there, the petitioner.
participated.
He has participated. He's been
What can you forget about all this? Just tell us, what can you do about these?
Now they participate in this. What will happen is that they've been given the relaxation that they will not appear for the preliminary entrance examination. They will directly sit for the mains. And that is on the 13th of July. One of them has already participated. Having participated, he cannot come here and say that you stay the proceedings. Now staying what's in
Is the person who is there here?
He is there, yes.
So the petitioner is participating.
Yes, Lordships. One of them has
He
participated.
might be that his case. What about others?
Lordships, others, because if Lordship stays, then it would affect all the persons who have.
I don't know, we somehow.
Lordships, there is.
Justice will have to be done. The earlier order is a little incoherent.
In fact, my lord, 906 was never subject matter of the writ petition at all.
It was the date of the 2015 order.
In fact, just see the direction. In the directions, the last direction at page 272 makes it very clear. It's in the context of 142, direction A.
For not issued the appointment orders in order to keep the appointment within the permissible person.
The power under 142.
The reservation, the power under Article 142 cannot be exercised.
So only appointment orders.
After this, 32 here, and your lordship give us liberty to go to the High Court. So,
No. The way it should be understood is that if it goes beyond 50%, there's nothing we can do about it. It's virtually a rejection.
but once your lordship said that Judge Singh made it clear, SCADA that you look at for 50%, there is no problem.
That's the.
I don't know. What underlining sympathy for you is there.
Yes.
But then there is no.
No, today we are here. Today we hear only on the. Today we hear only on the exam. I have one suggestion. We are here only on the exam that's going to be conducted on 13th of July, which is why we brought it up in urgency. Otherwise, it could have come later. Our only suggestion is if there can be a stipulation by then that this will be subject to the 906's claims regarding these vacancies.
Are those claims pending?
The claims are pending. Your lordship issued notice on this fact. If you take a look at the chart.
For the present, no orders.
Lordships may consider the examination can be held. Examination can be held subject to the rights of these.
The fact that these matters are pending here is enough indication that the further proceedings, further appointment process will be subject. And we have all the power to modulate it.
That is correct. But
we won't say anything over and above.
Can I make one submission? Can I make one submission?
Put up your matters for hearing. We will see. Let the exam.
But just one submission. The advertisement was issued in 2024. This new advertisement. We made that the subject matter of these SLPs before your lordship. We consciously, your lordships may recall, you asked us specifically. All 906 of us.
There was nothing which prohibited. In fact, it very, very clearly indicated that you will go ahead and participate in those proceedings. You take your chances. You don't even bother. At least the petitioner here has participated. That he has no legs to stand to argue.
We are on the. I must tell your lordship this. Those who challenged the original 2014 requisition were those who were not even eligible. They were not on the select list at all. We were on the select list. We were just made nominal parties because we were on the select list.
Your real problem.
If you draw an artificial line and cut us out, our only avenue is to file a fresh petition.
Unfortunately, I won't say anything more than that. You have actually lost out by virtue of this court's order.
This court's order, I may just submit, this court's order with regard to 906 was never the subject matter also of the writ petition. The writ petition was filed challenging the revised requisition.
By those who are not in the selection.
Yes, and the revised requisition has been upheld by your lordships.
No, we will not dismiss or anything like that. We will not pass any orders. List application.
Let your lordship's observation come, that it will be subject to the outcome of this.
Not that the examination will be subject to
Because we have
of the
brought
orders.
advertisement to your lordship well in time, Lord. In May itself, we have brought it to your lordship's notice.
Is there a direct challenge to the conduct of examinations?
It is in the interim,
Yeah,
in the SLP, the interim third prayer in my petition specifically says that no further
At
advertisement.
least as far as this petitioner is concerned, he has no legs to stand to argue.
There will be many petitioners
Having participated, because there are questions.
No, but are you saying?
Better not look at that.
As far as there is not a single
Take even a second.
not even in the first SLP, not even in the first
Don't state your case. It wouldn't take even a second for us to dismiss.
Not even in the first matter,
Try and see how we can.
not even in the first matter, about 150 people, only one of them. I will have a look at it.
Yes, take a note. Post after vacation.
Very good.
We'll try and see how best we can.
No, fair.
We'll try and work.
I'll fix a date because I understand
You
earlier.
also, in the meanwhile, just take instructions about some way you can accommodate these people also. And we will hear the matter if we are.
They have been given some opportunity that they've been bypassed the interview also.
Matters are still pending, yeah.
And they just to give them the examination, the main
All right.
exam.
Yesterday, I believe
The state must be fair enough.
Yes, they should.
You are causing damage to them for the past 12 years.
Lordship, the Supreme Court also has.
That's right.
And-
You are taking shelter under the order.
Lordship Court has. Lordship,
I understand till yesterday, the tentative date shown was 14th. Did it come up on 14th?
Sorry?
Till yesterday, I believe in all three matters, the tentative date being shown was 14th.
In these matters, yeah.
So your lordships will then take 14th.
Whenever it is coming up.
No, now the tentative date is changed to today.
Post along with the similar matters. Post along with the batch of similar matters.
Grateful.
Lordship, one thing, Lordship, in fact, they have challenged the advertisement, but they have not made UPPSC as a party because that's.
We'll do that.
They have to, in fact.
Serve the standing council.
Oblige.
The sad part of it is that the Pope.
Not for 12 years.
What happens is that 90% of their lives
Gone.
stuck in hope.
Yes.
No, I'm saying another thing. Gone are all right, but then the litigation, use hope by the end of it, we leave them in the lurch.
And in spite of selected
years passed by where they would have taken good positive decisions to recharge,
Also,
realign their lives.
my learned friend said,
Always be put under question mark.
yes, no, my learned friend said age relaxation. Advertisement is still for 12 years. What?
Take something else.
Yes.
I'm saying the real killer is the litigation. People's willpower to act positively is all lost because giving them hope, and then time takes over.
They will recalibrate your.
They realize it's too late. They would be age bar.
There are some
We will take it up early.
Yes.
We'll put an end to this.
But there are some IAs, maybe for implement, they are amongst these 906 people. They were not made parties. Some of them have been made parties.
What do you want?
The implement,
Implement
application.
Hear all of
They'll sail with us also.
Manoj sir, directly UPPSC as a party.
On our oral application, if you can do that, we will just.
PPSC is
My learned friend is there.
proceedings.
Some of them.
Anybody is appearing for them?
If he's appearing,
Let a copy of the special petition. Standing.
Next, comment the implement.
Item 5.
This is the key answer. Day before yesterday, we said NEET examination.
It's neat, but yes. Neat.
Similar matter we dismissed.
Day before yesterday.
Day before yesterday.
But 136, the question which I have raised, one minute, I
We are
can,
not going to interfere in it.
just give me a minute.
Identical matter.
So 136, question number 136, in the paper which was given to me,
It contained 4 options.
Exactly the same.
Same, but
One with the wind.
Then may I just look into that, my lord's petition?
Nothing.
No, I take it, my lords, once my lord says so, then definitely my lordship must be similar. Only for my satisfaction, my lord.
Okay, tell us, we will discuss this.
But kindly appreciate my lord. It's a
What
carrier
we
of
put to them, we'll tell you. You may be right on the principle that there could be multiple correct answers also. Despite that, to interfere in an all India national examination at this stage is going to put
my lord's last year, 2024, my lords have interfered. Only on one question.
After that, what we have done is
only on one question. Can we just have a look at it? Just have a look at it, man. Just have a look at it. So only one question.
The remedy is not an individual, Mr. Kala. What happens is that
NEET 2024, the Honorable Chief Justice Bench, my lord, similar, kindly have para 12. Kindly have para 12.
After that, what happened?
After that, they gave a direction. No, they gave a direction. Kindly see this.
Implementation of the orders.
Yes, implementation, para 14.
That's the separate judgment after this.
My lord, para 14. Initially, the answer key which was prepared by NTA indicated that the 4th option extracted above was the correct answer. Subsequently, on representation submitted to NTA, a decision was taken to the effect that both the second as well as the 4th options should be treated to be the correct answers. The 15 is most important. By an order of this court dated 22/7/24, the director IIT-Delhi was requested to constitute a 3-member committee to submit his opinion on which of the options noted above would be the correct answer to the above questions. The director and professor of Department of Energy Science, etc., then they gave this option. Now, having accepted this report, my lords, kindly, ultimately what my lords directed was, then the entire thing, para 21. Having answered the questions in the above terms, it needs to be clarified that if any student, including the present batch, as an individual grants not having any issues which have been rendered solved by this judgment, it will be open to them to prove their right, pursue their rights and remedies in accordance with law, including moving the so and so. What they directed, my lords, ultimately in para 18, and we just have para 18 for a moment. We accept the report of IIT-Delhi.
Be dismissed.
Ultimately, my lords, it's a carrier of the student. 1 mark will make
Carrier of thousands of students will be.
The thousands of students. That's why it is not only an individual case. It's not an individual case, but so many students should be in fact affected by this. And ultimately, my lords gave a direction in 2024 that you please actually revise the results based on the report of the IIT director.
Thank you.
Now,
My lords, passwords.
May lords only seek one indulgence, my lord. Let the committee be constituted, let the correct answer come the court. Let the correct answer come. Otherwise, my lords, what will happen is, I have actually given the correct answer because of somebody's insistence that it is actually answer B.
One that was tried, what the court had appointed a committee. NIT was asked to look into this matters. Committees of the court have come. Reformation, which needs to be done in multiple choice questions and all that is committee constituted. You don't know about that. But so they gave a report. The report led to the reforms committee to be appointed. The reforms committee, then that's how we need to tackle. We can't tackle individual examinations.
I moved on. But
that's the way to do it, not certified examinations.
But since actually there is a glaring manifest error on the answer key which was provided by the NIT. Therefore, my lord, that's why this actually petition was moved. Otherwise,
thank you.
I leave it at that. Obligement.
Made these elections. What here, the position is that it's election to the board of directors of a cooperative bank. Now, first there is preparation of voters list. So on 4th February, a notification is issued that 1st February 25 shall be the cutoff for being registered as a voter. Now, after that, the election program is announced on 5th June. The question is whether my, yes, eligibility has to be the date on which I was to be registered as a voter or the date on which the election program is announced.
What is the rule?
Rule is very clear. It is there, I have a separate compilation. Otherwise, the rule of that rule. Yes.
May I have the comparison?
Yes, yes, certainly, we will give it to you. Now, first kindly have, the rules are the first page on the compilation.
When is the election?
The voting is to take place on 10th of July.
10th of July.
My nomination was accepted.
Page.
Yes, first kindly at page 6.
Just come directly to the rule and then show us, don't go.
Yes, I'm not going here or there. Page 8, kindly have rule 9. This is in the compilation, page 8, rule 9. Provisional list of voters for societies having society and individual as members. A provisional list of voters shall be prepared for every society in the year in which the election of such society are due to be held. Their active members who have completed minimum 2 years from the date of their enrollment. In case society being a member who has completed 3 years from the date of enrollment.
Election process commences from which date?
Yes, page 18, page 12.